Welcome to So Ordered, where we create audio readings of SCOTUS decisions to make them more accessible to the public. At the time of creating this podcast, the Supreme Court of the United States does not release audio of the court's decisions. Our mission is to make it so the public can be better informed on decisions of the court by using AI to generate audio of written opinions. The case before us today is First Choice Women's Resource Centers versus Davenport, docket number 24781, decided April 29, 2026. Before reading the opinion itself, here is a brief summary of the case and the questions presented. First Choice Women's Resource Centers is a faith-based nonprofit that has counseled pregnant women in New Jersey since 1985 and does not provide or refer clients for abortions. In 2022, New Jersey's Attorney General served First Choice with an investigatory subpoena demanding 28 categories of documents, including the names and addresses of most of its donors. First Choice challenged the subpoena in federal court as a violation of its First Amendment rights, while the Attorney General moved to enforce the subpoena in state court. The lower federal courts held that First Choice's constitutional claims were not yet ripe for review. The question presented was, where the subject of a state investigatory demand has established a reasonably objective chill of its First Amendment rights, is a federal court in a first filed action deprived of jurisdiction because those rights must be adjudicated in state court. The court held First Choice has established a present injury to its First Amendment associational rights sufficient to confer Article III standing. Justice Gorsuch delivered the opinion for a unanimous court. As a reminder, the audio is an AI-generated reading of a published opinion of the Supreme Court of the United States. The voice you will hear has been synthesized to loosely resemble that of the justice that wrote the opinion. All tone, inflection, pacing, and emphasis are produced by the AI model and should not be attributed to any justice. The text itself has been lightly adapted to aid in the creation of the spoken delivery. Please remember, this is a project to attempt to make court decisions more accessible to the public, and any substantive changes during the reading are completely unintentional. Please visit www.supremecourt.gov to read the opinion published by the court. One final note, during the reading you may hear glitches. Please know we are aware of the glitches and are working to improve over time. The following is the opinion of the court in First Choice Women's Resource Centers versus Davenport.
New Jersey's Attorney General served a subpoena on a nonprofit organization demanding the identities of its financial supporters. We consider whether that organization may challenge the subpoena's constitutionality in federal court. First Choice Women's Resource Centers Incorporated is a religious nonprofit organization that has provided counseling and resources to pregnant women in New Jersey since 1985. Believing that life begins at conception and seeking to protect and honor life in all stages of development, the group does not provide abortions or refer clients to others for abortions. In 2022, New Jersey's Attorney General, Matthew Platkin, established a Reproductive Rights Strike Force. Shortly after its creation, the Strike Force issued a consumer alert in which it accused groups like First Choice of seeking to prevent people from accessing comprehensive reproductive health care by providing false or misleading information about abortion. The alert concluded by directing women to abortion providers and asking members of the public who believed they were victims of fraudulent, deceptive, misleading, or unlawful conduct to please file a complaint with the New Jersey Division of Consumer Affairs. Neither that division nor the Attorney General's office received any complaints from the public about First Choice. Even so, the Attorney General served a subpoena on the group in 2023. The subpoena stated that it had been issued pursuant to several New Jersey laws, including the state's Consumer Fraud Act. The subpoena commanded First Choice to produce various documents within 30 days and warned the group twice that failure to comply with this subpoena may render you liable for contempt of court and such other penalties as are provided by law. In all, the Attorney General demanded production of 28 categories of documents, categories that themselves included as many as 29 subcategories. Most relevant for our purposes, the subpoena directed First Choice to disclose documents reflecting the names, phone numbers, addresses, and places of employment of all individuals who had made donations to First Choice by any means other than through one specific web page. Effectively, That demand required First Choice to provide personal information about donors who gave through 2 other websites, through the group's various social media pages, by mail, in person, or by any other means. Jennifer Davenport's name appears in the caption of this case because she succeeded Mr. Platkin as New Jersey's Attorney General after this case was argued and submitted for decision. The subpoena sought documents about donations received over the span of multiple years, beginning from January 1, 2021, and extending to the date of First Choice's response. Though the subpoena did not explain why the Attorney General sought First Choice's donor records, Mr. Platkin later represented that his office hoped to contact a representative sample of donors to determine if they had been misled by First Choice about its mission and operations. In his view, First Choice's solicitation materials, including a donation webpage featuring pictures of parents holding infants and young children, could mislead donors into thinking First Choice provides abortions. 2 days before the deadline to produce documents, First Choice filed suit in federal district court seeking to prevent the Attorney General from enforcing his document demands. Shortly after that, the Attorney General responded with his own suit in state court. There, he accused First Choice of violating state law by failing to comply with his subpoena. Between the 2 suits, much litigation followed. In the federal case at issue here, matters unfolded this way. A federal law, 42 United States Code, Section 1983, authorizes suits against any person who, under color of state law, deprives another of his federal constitutional rights. First Choice filed a complaint under that statute, arguing, among other things, that the Attorney General's demand for information about its donors violated its First Amendment rights. Specifically, First Choice observed that the First Amendment prohibits the government from discouraging people from associating with others in pursuit of many political, social, economic, educational, religious, and cultural ends. And, First Choice alleged, the Attorney General's subpoena had just that impermissible effect. For its donors, the group represented, anonymity is of paramount importance, and its inability to guarantee that anonymity in the face of the Attorney General's demands injured the group by discouraging donors from associating with it. In addition to its complaint, First Choice filed a motion seeking a preliminary injunction prohibiting the Attorney General from enforcing his subpoena. In support of its motion, First Choice tendered 2 declarations. In one, anonymous donors represented that, if they had known information about their donations might be disclosed to an official hostile to pro-life organizations, each of them would have been less likely to donate to First Choice. The donors added that they submitted their declaration anonymously because they believed they might face retribution otherwise, given the Attorney General's record of hostility toward pro-life groups. In the second declaration, the group's executive director similarly represented that the Attorney General's request threatened to weaken First Choice's ability to recruit new donors, as prospective partners would be hesitant to risk the revelation of their personal information through government investigation. Ultimately, the district court issued an opinion both denying First Choice's motion for a preliminary injunction and dismissing its complaint. Without questioning First Choice's allegations or evidence, the court held that the group failed to state a justiciable claim as a matter of law. In reaching that conclusion, the court pointed to the ongoing state court suit. In it, a judge had directed the Attorney General and First Choice to negotiate their disagreements over the subpoena, but had not yet compelled First Choice to disclose materials that the group believes are constitutionally protected. Given the absence of any state court order compelling production, the district court reasoned, First Choice had yet to suffer any injury from the subpoena, and thus lacked Article III standing to challenge it in federal court. To be sure, the district court recognized an argument could be made that the subpoena itself, by virtue of being issued, was causing First Choice an ongoing injury to its First Amendment rights. But, the court held, that injury was insufficient to confer standing. Indeed, the court worried that allowing the federal litigation to proceed while state proceedings remained ongoing would not be tolerable to our nation's federalism. A divided panel of the Third Circuit affirmed. Much like the district court, the majority reasoned that First Choice had not established enough of an injury to permit its case to proceed. Judge Bibas dissented. He would have found the case justiciable because the subpoena's issuance burdened First Choice's present ability to associate freely with its donors. This case presents a narrow question. We are not asked to decide the merits of First Choice's federal lawsuit, only whether it may proceed. Article 3 of the Constitution vests federal courts with the judicial power to decide cases and controversies. Section 2, Clause 1. Inherent in that assignment is a standing requirement consisting of 3 elements: injury in fact, causation, and redressability. Diamond Alternative Energy, LLC against EPA, decided in 2025. Together, these elements help us distinguish cases and controversies fit for judicial resolution from questions of public policy reserved to the elected branches or abstract disputes better left to the debating hall. As this case comes to us, it centers on the injury, in fact element. To satisfy that element, a case must involve an injury that is concrete, particularized, and actual or imminent. Because this standard tolerates suits involving actual or imminent injuries, a party need not always wait for the government to take coercive action against it before filing suit to challenge the government's conduct. Instead, a litigant may bring a pre-enforcement suit seeking prospective relief against government officials so long as it faces a credible threat of enforcement. See Susan B. Anthony List against Driehaus, decided in 2014. Before us, First Choice advances 2 arguments for why it can satisfy the injury in fact requirement. First, the group submits that the Attorney General's subpoena itself, and specifically its demand for donor information, has caused it to suffer an actual and ongoing injury to its First Amendment rights by deterring donors from associating with it. Second, First Choice contends that it faces an imminent future injury because with the subpoena came a credible threat that the Attorney General would seek to enforce it in state court if the group failed to comply. For our purposes, it suffices to address only the first theory, as it is enough to carry the day. The First Amendment guarantees all Americans the rights to speak, worship, publish, assemble, and petition their government freely. Each of these rights, this court has long understood, necessarily carries with it a corresponding right to associate with others. Americans for Prosperity Foundation v. Bonta, decided in 2021, and Roberts v. United States, decided in 1984. Without such a right, no 2 men could safely share the same soapbox, no 2 women the same church. The government could reduce any assembly to a party of 1, and the right to petition would amount to nothing more than the power to sign one's own name alone. Appreciating all this, we have held that government actions tending to curtail the freedom to associate warrant the closest scrutiny under the First Amendment. NAACP against Alabama ex rel. Patterson, decided in 1958. We have recognized, too, that associational rights carry special significance for political, social, religious, and other minorities. With the freedom to associate, minorities can show their numerical strength, influence policy, and stimulate competition in the marketplace of ideas. But take that freedom away and dissident expression stands particularly vulnerable to marginalization or outright suppression by the majority, leaving all of society poorer for it. Roberts. Our cases have held that governments can infringe freedom of association in varied ways. For example, governments might require a group to accept members it does not want, deny benefits to an organization based on its message, or punish individuals for their affiliations. See Boy Scouts of America against Dale, decided in 2000, Healy against James, decided in 1972, Elrod against Burns, decided in 1976 plurality opinion. We have also held that compelled disclosure of affiliation with groups engaged in advocacy can constitute an effective restraint on freedom of association. NAACP against Alabama. NAACP against Alabama addressed this last problem in its starkest form. Responding to the NAACP's efforts to promote integration in Alabama in the 1950s, the state's Attorney General and future Governor John Patterson brought a lawsuit in state court. In it, he contended that the NAACP was operating illegally in Alabama because it had failed to register with the Secretary of State as required by state law. NAACP against Alabama. As remedy, he sought a judicial decree effectively banning the organization from the state. And to prove his allegation that the NAACP was operating in Alabama, Mr. Patterson demanded the names and addresses of all NAACP members and agents in the state. When the organization refused to disclose its membership rolls, a state court imposed a sanction of $100,000, over $1 million today's value, and the Alabama Supreme Court let the sanction stand. This court reversed that judgment. In doing so, we began by observing the vital relationship between privacy in one's associations and the freedom to associate. Strip away the ability of individuals to work together free from governmental oversight and intrusion, and the freedom to associate may become no freedom at all. Individuals deterred, groups diminished, and their protected advocacy suppressed. Nor, we added, is it a novel perception that these outcomes are particularly likely to follow when the government seeks to intrude into the workings of groups that hold dissident beliefs, disfavored by those holding the reins of power. Applying these observations to the case at hand, we held that the Attorney General's demand for the NAACP's private membership rolls burdened the constitutional right of the organization's members to pursue their collective effort to foster beliefs which they admittedly have the right to advocate, given the demand's tendency to induce members to withdraw from the association and dissuade others from joining it. Because the Attorney General had not identified any interest sufficient to justify the deterrent effect associated with his disclosure demand, we continued, it could not be sustained. Since NAACP against Alabama, we have faced many cases along similar lines. In them, one state authority or another has demanded private donor or member information. And in one case after another, we have subjected those demands to heightened First Amendment scrutiny. Throughout, we have emphasized the critical role privacy and association plays in preserving political and cultural diversity and in shielding dissident expression from suppression. We have acknowledged, too, that demands for private donor information inevitably carry with them a deterrent effect on the exercise of First Amendment rights. Buckley against Vallejo, decided in 1976 per curiam. See, for example, Bates against Little Rock, decided in 1960, Louisiana ex rel. Gramillion against NAACP, decided in 1961. Gibson against Florida Legislative Investigation Committee, decided in 1963. Brown against Socialist Workers Campaign Committee, decided in 1982. Our most recent encounter with the demand for donor information came 5 years ago in AFP. There, California Attorney General Rob Bonta sent deficiency letters to the Americans for Prosperity Foundation and the Thomas More Law Center, the first, a charity devoted to education and training about constitutionally limited governments. The second, a public interest law firm whose mission is to protect religious freedom, family values, and the sanctity of human life. In his letters, Mr. Bonta sought the names and addresses of anyone who donated more than $5,000 in a single year to either group. When the organizations protested that they kept donor information private out of concern for their donors' anonymity, the Attorney General responded by threatening fines and the suspension of each organization's status as a tax-exempt charity. We held that the state's demand, like others before it, violated the First Amendment. To be sure, the Attorney General tried to downplay the impact his demand had on associational rights, stressing that he promised to keep the group's donor information to himself and prohibit its public dissemination. But we found that promise of no moment. Demands for private donor information, we held, chill, protected First Amendment associational rights, even when those demands contemplate disclosure only to government officials and not the general public. Quoting Shelton against Tucker, decided in 1960, so any demand for donor information, we said, must overcome heightened First Amendment scrutiny, given the deterrent effect on the exercise of First Amendment rights that arises as an inevitable result of the government's conduct. Nor, we ruled, could the Attorney General satisfy heightened First Amendment scrutiny, as his document demand was not sufficiently tailored to serve the government interests that he asserted. Against this backdrop, the question before us all but answers itself. First Choice has established a present injury to its First Amendment associational rights. Start with the Attorney General's subpoena. It told First Choice, "You are hereby commanded to produce a variety of documents, including ones sufficient to identify donations made to First Choice by any means other than through one web page." The subpoena defined the term identify as requiring First Choice to provide each donor's a full name, B, present or last known address, C, phone number, and D, present or last known place of employment. Twice, the subpoena warned First Choice that failure to comply with the subpoena may render you liable for contempt of court and such other penalties as are provided by law. Next, recall First Choice's complaint. Because the district court dismissed this suit for lack of subject matter jurisdiction as a matter of law, the parties take as given that we may treat all the complaint's well-pleaded allegations as true for purposes of our analysis. In its complaint, First Choice alleged that it keeps donor information private. The group alleged, too, that the Attorney General had publicly called pro-life groups extremists and suggested that charges might be brought against them. Given this, the complaint continued, the Attorney General's demand for donor records discourages individuals and entities from associating with First Choice, out of fear that they themselves will face retaliation. And, First Choice asserted, the risk of loss of donors greatly jeopardizes its ability to carry out its religious mission. Finally, consider First Choice's two unrebutted declarations. In the first, several donors represented that each of us would have been less likely to donate to First Choice if we had known information about the donation might be disclosed to the Attorney General. The donors added that they submitted their declaration anonymously because they feared what they called the Attorney General's record of hostility toward pro-life groups. In the second declaration, First Choice's executive director stated that the Attorney General's demand threatened to weaken the group's ability to recruit new donors, as prospective partners would be hesitant to risk the revelation of their personal information through government investigation. All this is more than enough to establish injury, in fact, under our precedents. An injury, in fact, does not arise only when a defendant causes a tangible harm to a plaintiff, like a physical injury or monetary loss. It can also arise when a defendant burdens a plaintiff's constitutional rights. See TransUnion, LLC against Ramirez, decided in 2021, and our cases have long recognized that demands for a charity's private member or donor information have just that effect. They discourage people from associating with groups engaged in protected First Amendment advocacy, NAACP against Alabama. They also encourage groups and individuals to cease or modify protected First Amendment advocacy the government disfavors. See Shelton. All this occurs not just when a demand is enforced, but when it is made and for as long as it remains outstanding. As we have put it, a demand for private donor information inevitably deters the exercise of First Amendment rights, Buckley, and can do so as effectively as other forms of governmental action might in NAACP against Alabama. A more general principle, too, confirms the specific lesson our cases teach on this score. Across contexts, we have said, Courts may make common-sense inferences when assessing Article 3 standing, including inferences about third-party behavior. Diamond alternative energy. And organizations spanning the ideological spectrum confirm the reasonableness of the inferences our cases have drawn about the burdens that demands for private donor information inevitably impose on protected First Amendment rights. Groups ranging from the American Civil Liberties Union to the National Taxpayers Union Foundation to the Church of Jesus Christ of Latter-day Saints have filed briefs in this case explaining that, even if a subpoena targeting First Amendment activity is never enforced in court, it will give its targets a very good reason to clam up and give the target organization's members and supporters a very good reason to abandon the cause. Worse, amici represent, officials across the political spectrum have sometimes issued subpoenas and other investigatory demands in order to secure just these results. Each of these strands tightens the braid into one conclusion. From its allegations and declarations, and given our many and long-standing precedents in the area and reasonable inferences about third-party behavior, First Choice has established that the Attorney General's demand for private donor information injures the group's First Amendment associational rights. The Attorney General does not dispute much of this. He admits that a party suffering an objectively reasonable chill to its First Amendment associational rights has an injury in fact sufficient to give rise to Article 3 standing. He does not question that an official demand for private donor information can objectively chill a charity's protected First Amendment associational freedoms. First Choice contends that our First Amendment charitable solicitation precedents independently support its assertion of a present Article 3 injury. We have held that the First Amendment speech clause protects the right to solicit charitable contributions. Americans for Prosperity Foundation against Bonta, decided in 2021. See also Schomburg against Citizens for Better Environment, decided in 1980. That right limits a government's ability to make demands of charities that would have the predictable result of rendering their solicitations unsuccessful. Riley against National Federation of Blind of N.C. Incorporated, decided in 1988. Given our conclusion that First Choice has standing on other grounds, we have no need to resolve whether Mr. Platkin's disclosure demand burdens the group's solicitation rights. Notably, too, Mr. Platkin declines to defend the district court's ruling that our nation's federalism does not tolerate First Choice's effort to have a federal court adjudicate its federal suit while state court litigation over the subpoena remains ongoing. Nor does Mr. Platkin defend the Court of Appeal's similar assessment that First Choice must first litigate its constitutional objections in state court in order to ripen its constitutional claims. He does not defend the lower court's views for good reason. First Choice brought this suit under 42 United States Code, Section 1983. Congress enacted that provision with the express goal of ensuring a federal forum to citizens who claim that state actors have violated their constitutional rights. See Nick against Township of Scott, decided in 2019. And federal courts have a virtually unflagging obligation to exercise the jurisdiction given them. Sprint Communications Incorporated against Jacobs, decided in 2013. See also Nick. Of course, certain abstention doctrines supply narrow exceptions to that rule when state proceedings are ongoing. See, for example, Younger against Harris, decided in 1971. But the lower courts did not find, and Mr. Platkin does not argue, that any of this court's abstention doctrines apply to this case. Despite all this, the Attorney General insists that First Choice has not suffered any injury and thus cannot maintain this lawsuit for 3 reasons. First, he contends that the subpoenas his office issues are non-self-executing, and subpoenas of that sort cannot objectively chill First Amendment rights as a categorical matter. Second, he claims that, even if non-self-executing subpoenas can objectively chill First Amendment rights, the subpoena he issued to First Choice did not. Third, he suggests that, even if his subpoena did objectively chill First Choice's associational rights when he issued it, his later promise to refrain from making First Choice's donor information public effectively cured that chill. Take each argument in turn, starting with the Attorney General's most ambitious submission. He says that subpoenas issued by his office are non-self-executing. Translated, that means they impose no obligations of their own. Instead, any legal duty to produce records arises only when a court agrees to enforce the subpoena. Categorically, he says, this means a recipient of a non-self-executing subpoena like the one he issued to First Choice suffers no injury unless and until a court enforces it. This conclusion does not follow from its premises. The value of a sword of Damocles is that it hangs, not that it drops. Arnett against Kennedy decided in 1974. Much the same holds true for the subpoena before us. It commanded First Choice to produce private donor information, and it warned that failure to comply may render the group liable for contempt of court or other penalties. Whether that command and those penalties were immediately enforceable or depended on subsequent court action, the most First Choice could say to existing and prospective donors after receiving Mr. Platkin's subpoena was that their privacy might be protected, or it might not. Objectively reasonable people interested both in their privacy and in associating with First Choice would not lightly disregard such a distinct possibility of disclosure. Intim Books, Incorporated against Sullivan, decided in 1963. An objectively reasonable recipient of a demand like that would be induced as well to trim its protected advocacy, knowing it now stands in the government's crosshairs. See NAACP against Alabama, Shelton, Virginia against American Booksellers Association, decided in 1988 self-censorship in response to a well-founded fear that the law will be enforced against them is an injury, in fact, that can be realized even without an actual prosecution. Seeking to persuade us otherwise, the Attorney General tries to analogize this case to Laird against Tatum, decided in 1972, where we found the plaintiff's alleged First Amendment injury merely subjective and self-imposed, and thus insufficient to create a justiciable controversy. But this case is nothing like that one. There, the plaintiffs alleged that their First Amendment associational rights were chilled not by any specific action against them, but by the mere existence, without more of a government program they thought was inappropriate or dangerous. Here, by contrast, the Attorney General targeted First Choice for investigation. He commanded production of its private donor information, and his command, even if not immediately enforceable, is backed by a threat of court-ordered compliance, followed by the possibility of sanctions should First Choice resist. Failing in one analogy, Mr. Platkin attempts another. This time he points to Pactel against City and County of San Francisco, decided in 2021 per curiam. In that case, we explained that a plaintiff normally cannot sue in federal court over an alleged regulatory taking until local land use authorities commit to a position regarding how the regulations at issue apply to the particular land in question. Applying the same logic here, Mr. Platkin insists, means that First Choice should not be allowed to challenge his subpoena in federal court until state court proceedings have run their course. Until then, after all, his non-self-executing subpoena is subject to negotiation, and it remains uncertain which of its demands will be enforced. But even setting aside the question whether a takings clause rule might be properly transposed into the First Amendment context, the rule Mr. Platkin invokes has little purchase here. He committed to a position when he issued his subpoena demanding donor records. To be sure, he remained free to narrow the scope of his demands later, and he might fail to secure a judicial order compelling production. But none of this means he failed to commit to a position, nor does any of this undo the inevitable injury First Choice experienced to its associational rights when Mr. Platkin issued his subpoena, an injury that it continues to experience so long as the subpoena remains outstanding. Buckley. Below, the district court offered still another analogy to the same end. It pointed to lower court decisions applying Reisman against Kaplan, decided in 1964. In Reisman and its cousin FTC against Claire Furnace Company, decided in 1927, this court confronted efforts to enjoin non-self-executing federal administrative subpoenas before a court directed their enforcement. See Reisman, Claire Furnace. In both cases, we read the governing statutes in question as preferring federal court review only after the government sought to compel production. See Reisman, Claire Furnace. And in both cases, we held that the availability of federal court review on the back end provided the plaintiffs an adequate remedy at law, which meant that their preemptive requests for injunctive relief were subject to dismissal for want of equity. Reisman reciting the usual rule that an equitable remedy is unavailable when an adequate remedy at law is available, accord Claire Furnace. In much the same way, the district court concluded, First Choice cannot sue preemptively to challenge the Attorney General's subpoena, but must instead wait for the state court litigation to play out. This analogy works no better than its predecessors. First, the plaintiffs in Reisman and Claire Furnace did not allege a present injury from the subpoena itself, but complained only of future injuries they might face if a court enforced the subpoena. See Reisman, Claire Furnace. Because a person in those plaintiffs' shoes would suffer no injury while testing the subpoena in federal court, we were able to find that the remedy specified by Congress, that is, review upon enforcement, works no injustice and suffers no constitutional invalidity. Reisman. The same conclusion does not follow in cases like this one, where a plaintiff suffers ongoing injuries from the subpoena itself. See Media Matters for America against Paxton, decided in 2025. Second, Reisman and Claire Furnace concerned equity practice, not Article III standing, and the adequate remedy at law. We found sufficient to divest us of equitable authority in those cases, involved litigation in federal court when the federal government would sue to enforce the subpoenas at issue. See Reisman, Claire Furnace. Here, by contrast, the district court sought to force First Choice to litigate in state court before coming to federal court. That difference matters because, even as a matter of equity practice, it is settled that no adequate remedy at law exists, so as to deprive federal courts of equity jurisdiction, unless it is available in the federal courts. Petroleum Exploration, Incorporated against Public Service Commission, decided in 1938. Third, our cases have already rejected the notion that a litigant must exhaust available state court remedies before seeking to vindicate its federal constitutional rights in federal court under Section 1983. Nick. Section 1983 guarantees a federal forum for plaintiffs who claim unconstitutional treatment at the hands of state officials, requiring plaintiffs to exhaust state court remedies before they may avail themselves of Section 1983's promise, we have said, would hollow out the statute. Such a rule, too, would threaten litigants with a preclusion trap. Under it, a plaintiff who goes to state court and loses would find its claim forever barred in federal court under principles of res judicata. In that way, Section 1983's promise of a federal forum would die a-borning. B. Moving from the categorical to the case-specific, the Attorney General submits that, even if a non-self-executing subpoena-seeking donor information can objectively chill First Amendment freedoms, his subpoena to First Choice did not. Yes, that subpoena sought information about those who donate to the group by almost any means, whether in person, over the phone, or online. But, the Attorney General stresses, the subpoena did not seek information about individuals who give through one website. The Attorney General says he is content. This specific website could not mislead a potential donor into thinking that First Choice provides or refers for abortions. Accordingly, he will permit First Choice to solicit funds through that avenue without disclosing the identities of those who donate through it. That permission, the Attorney General submits, means First Choice has suffered no First Amendment injury. This argument misapprehends the Article 3 standing inquiry. A government that takes 3 limbs but spares the last imposes an injury all the same. So too here. The question before us isn't how badly the Attorney General has burdened First Choice's associational rights. The question is whether he has burdened those rights at all, and by effectively restricting how First Choice may interact privately with its donors, the subpoena did just that. Were the rule otherwise, the government could channel the ability of disfavored groups to associate through narrow and state-preferred forms. In doing so, it could achieve exactly what the First Amendment forbids, marginalizing dissident voices and reshaping the marketplace of ideas to its pleasure, all while evading any legal challenge to its actions. None of that is consistent with our Constitution, which prohibits subtle interference with protected liberties no less than it does heavy-handed frontal attacks. In a separate but similar vein, Mr. Platkin contends that any injury initially associated with his subpoena dissipated later. On the day before oral argument in the Third Circuit, he sent a letter to First Choice indicating that he would be willing to narrow his demands and accept information about donors who give through just 2 websites. At least that, Mr. Platkin maintains, was surely enough to end any injury his subpoena imposed and moot this case. Not so. A defendant seeking to moot a case by abandoning his injurious conduct carries a heavy burden. Trinity Lutheran Church of Columbia, Incorporated against Comer, decided in 2017. Among other things, he must prove no reasonable expectation remains that he will return to his old ways. FBI against Feker, decided in 2024. That is a standard Mr. Platkin cannot meet. His letter expressly reserved the right to seek identities of other donors through a separate subpoena. Even more than that, he continued to insist on the disclosure of donor information collected through 2 websites. As with his earlier offer to allow anonymous donations through 1 website, this later proposal might have mitigated the scope of First Choice's injury, but it did not extinguish it. In a last push, the Attorney General suggests that his demand cannot injure First Choice because a state court will soon, and with his assent, issue a protective order requiring him to keep confidential any documents the group produces. As a result, First Choice and its donors have no need to worry about donor information becoming public. This response fares no better than the rest. Put aside that no such protective order presently exists. Put aside the possibility that, even with a protective order in place, donor information might wind up in the public domain due to a hack or leak. Put aside the risk of harassment or reprisals that could invite. And put aside that risks along those lines are heightened in the 21st century, where almost anyone with a computer can access information once it migrates to the public domain. Even taken on its own terms, this response falls short. An official demand for private donor information is enough to discourage reasonable individuals from associating with a group. It is enough to discourage groups from expressing dissident views. A government that chooses to make private donor information public may make the damage worse. But even if there is no disclosure to the general public, the pressure, to avoid ties in speech which might displease. Officials demanding disclosure can be constant and heavy. Shelton, see also, AFP, assurances of confidentiality do not eliminate the First Amendment injury caused by a demand for private member or donor information. Just ask yourself, would it have been an answer in NAACP against Alabama if the state's Attorney General promised to keep the NAACP's membership rolls to himself? Since the 1950s, this court has confronted one official demand after another like the Attorney General's. Over and again, we have held those demands burden the exercise of First Amendment rights. Disputing none of these precedents, but seeking ways around them, the Attorney General has offered a variety of arguments. Some are old, some are new, but none succeeds. Accordingly, the judgment of the Third Circuit is reversed, and the case is remanded for further proceedings consistent with this opinion. It is so ordered.